May it please the court. My name is Matt Benda, and I represent the appellants in this matter. Every voter's vote is entitled to be counted once. It must be correctly counted and reported. This simple statement from the U.S. Supreme Court in the case of Gray versus Sanders is quoted at the beginning of my brief and serves as the guiding light of my argument today. This case goes on to state, the right to have one's vote counted has the same dignity as the right to put one's ballot in a box. We are here today to confirm that these same dignities can be protected in the election process in Minnesota. Voting has evolved rapidly from the simple process of dropping a ballot in a box on election day to a complex framework where voting starts weeks in advance and electronic machines are used almost exclusively to accept, tally, and report vote totals. The ongoing evolution of voting justifies dynamic scrutiny of the entire process to protect the dignity of counting and reporting votes correctly. I am here today to say loud and clear, Rice County and at least 6 other counties in Minnesota have wireless modems embedded in their election machines, which opens them up to internet access. We argue that this unsettling fact violates the ban under Minnesota Statute 206.845, which reads, "No connection by modem is permitted." These modems are also part of a voting system under Minnesota Statute 206.57, which requires them to be examined and certified. The Secretary of State has not met this requirement. Section 204B.44 provides a legal framework to scrutinize and correct these 2 election errors. Eventually, there will be some type of snafu in the use of electronic voting machines in Minnesota. Either the power will go out, data will be lost or compromised, or in a worst-case scenario, a bad actor infiltrates our electronic election process. We need 204B.44 to be ready for that circumstance. Uncomfortable topics should not make bad law. The Court of Appeals selectively triggered service of process as a barrier to jurisdiction. Justice Ruth Bader Ginsburg referred to this judicial act as a drive-by jurisdictional ruling. This should not be a pick-and-choose process that causes confusion. In this case, per the canvassing results from Rice County, the Court of Appeals decision would have required personal service on over 130 individual candidates, including 3 of you sitting here today. All of that just for the court to obtain jurisdiction over an error in admissions action. The service language of 204B.44 that was added in 2014 was clearly intended to create judicial efficiency, not create an inefficient, expensive, and cooling process. This statute serves to protect voters, not perpetuate chaos. I'm here today to request that you reverse the inconsistent and erroneous ruling of the Court of Appeals and remand this case back to District Court. Thank you.